Assoc there. I've only been to Edinburgh and around there, but my sister, she spent some time up at Fort William.
Oh yeah, you need to go out to the West Coast. I mean, that's the... But you know, you'll know this from home, that on a rainy day, you would probably wish to be anywhere else in the world. Yeah. But on a glorious sunny day, it's as good as anywhere. You know, if you get lucky, it could be just stunning.
Yeah.
And the islands as well. That's the islands. It's very special.
My wife said to me, because I said, I wouldn't mind when we retire to live up there. She said, I don't know whether you'd really want to live up there.
Yeah. I think people go in the summer and say they want to live up there, and then they get through their first winter and maybe think again.
Yeah. Anyway.
Yeah.
Anyway, I think we're doing all right at the moment. Fingers crossed.
Well, fingers crossed.
Don't you think?
That's the main thing.
It's going to be a bit better than the way.
It's definitely better, isn't it? I mean,
I think it is
immeasurably better, but you know, it's just. I just think, you know, last summer, you know, early summer, we were thinking that's the end. We've done it now. We've done and now you sort of think, what is the coming winter going to be like? I'm sure we'll have a good summer. I'm sure we'll be able to have a proper summer. But who knows what the autumn will be.
Yes, exactly. But fingers crossed.
Fingers crossed. Just got to enjoy it now, haven't we?
Yeah. Well, they all out there, are they? Just two. Right.
Thinking about, are you with us? Sorry, I've asked you already. Next week.
I'm with you.
Did you hear? She's just asked Warby about next week in court. And he's all right with it.
Oh,
what do you think?
Oh, yes.
I'm all right with it.
Yeah, well, I'm ready, yeah.
I prefer it.
But a lot of people are not like us.
Yeah, I mean,
But
This is scheduled for
I mean, it
today.
saves me
no, it's only one.
doing all
We're
the
going to
bits.
finish today anyway, whether it's scheduled for.
Well, no.
All right,
Yes and no. I still have to.
Cool.
I still need to contact.
We'll be finished.
I did it last time. And I said, "Oh, you've done my work for me." I said,
Yeah.
"Oh, that's good."
So that's a bookmaker's problem.
Yeah, what's wrong? Did you ask to bring
Well, I'll be the opposite of Lewis. You'll be the baby. So everyone else can. Do you know what I mean?
Yeah.
That's okay. Right. Oh, I've got to get my. Oh, yeah, the pass back. One day I forgot it. I changed bags. I got it. Get me a pass.
Court rise.
Yes, Mr. Wise. My lords, my lady, we were considering the proportionality analysis conducted by the judge in this case. The court was taken to what he said at the second half of paragraph 217 of his judgment, and we were making the point that in those two sentences there, our submission is that that's a cursory and perfunctory assessment rather than the detailed analysis that is required. We were looking at the first sentence, giving weight to proportionality assessment of the ministerial submission and the regulatory triage assessment. And in answer to my Lady Justice Laing, we are clear that obviously he was entitled to do that, but what he doesn't say is what weight he gave to what particular factors in those assessments and in those two documents, and why he gave particular weight to which of the particular factors. So merely saying that he gave some weight, how much weight? It really begs more questions than it answers in our submission.
So what's missing? What's he supposed to say?
He's supposed to weigh up the factors in those documents. He doesn't even say what they're about.
But he's supposed to say, I attribute 100 grams to this and 200 grams to
no,
that. I mean,
no, not at all. It's any balancing exercise, of course, has to put the pros measure the pros and cons as the ministerial submission itself does, and then say which side of the balance he falls and why. It's not a mathematical exercise, of course it isn't.
No.
But at least one would the least one that is required is to set out which particular factors get attached, what particular weight, i.e., what were the most important factors in making coming to the
Well, you don't mean
conclusion.
particular weight because you've eschewed that. You mean relative weight.
Well, relative. Sorry, yes, I do mean that.
Right.
And the other problem, of course, is one's always measuring things which are by their nature incommensurable.
Well,
so,
absolutely.
I mean, ultimately, isn't it really the conclusion that matters? I mean, I agree a degree of spurious accuracy may be given by going through the motions and ticking all the boxes, but I mean, frankly, it doesn't really amount to much more than this, does it, in the end, than the judge's own feeling as to what the right outcome is.
Well, that certainly isn't the way that Lord Sumption and the majority of the Supreme Court approached it, Lord. Neither was it the way that Mr. Justice Green, as he then was, interpreted what the Supreme Court said.
But in the Bank Mellat case, there was something more to get your teeth into because there was an evident and unexplained difference of treatment between Bank Mellat on the one hand and the other Iranian banks on the other hand. That there isn't a similarly hard-edged issue here.
Well, there is, with respect, my lady, we say that there is. Electric shocks are impermissible if controlled by a remote device, but they're permissible if they're controlled by an electric fence, a containment system. So there are comparators that can be made. And the way I described it earlier, ladyship will recall, is the mischief that sought to be addressed. Old-fashioned language, I know, but I think it's probably appropriate in these circumstances. The mischief in Bank Mellat obviously was the conduit for the arms business and program. The mischief that sought to be controlled here is the use of electric shocks on animals. So we do have comparators, and it is incumbent upon, as Lord Sumption makes absolutely clear, it is incumbent for decision makers to consider all those who fall within those parameters. And Bank Mellat's in an A1P1 context, as we are here. With the obvious rider that Lord Sumption makes, that these aren't the same as in the same category as human issues. The right to property and run a business is a fundamental right. It needs, and any removal of that right to do that business needs to be properly explained and understood. It can't be done in such a cursory way, we say. So that's the first sentence of the proportionality analysis. The second sentence, as we see, in any event, in my judgment, the burden of the ban, excluding containment systems, upon the claimants' members is not so substantial or so excessive as to be disproportionate when set against the benefits of promoting animal welfare. But that's merely stating what the balancing exercise should be in the conclusion. It doesn't say how he's arrived at that conclusion. It's impossible to characterise that as an exacting analysis. There's no evidence there, for example, of the consequences of the ban being put into the balance, and particularly what would happen to those animals who are currently are controlled by remote devices, who wouldn't be able to under a ban. There are very valid welfare issues. We set them out at paragraph 60 of our Skeleton argument. One of which, Can I take your lordships and your ladyship to that? Page 24, paragraph 60D.
Sorry, page.
Page 24 of the skeleton, my lord.
Oh yes, I did.
I've been
yes,
careful
but,
not to just go through the skeleton.
No,
I
thank
mean, it
you.
doesn't really serve much
No,
purpose.
thank
I
you.
take it that the court's read it anyway.
Indeed.
Page 24, do you see the D towards the top of the page?
Yeah.
This is the context of this paragraph is, as we see from the previous, the crucial factors that we say were wrongly omitted from the consideration in the balancing exercise. The fact that the banning of e-collars would be likely to create or exacerbate other animal welfare issues, including the increased use to fill a vacuum created by the ban of other aversive training techniques, such as choke chains and prong collars, and forcing the use of e-collars underground, such that low-quality, unregulated products may be used more frequently. A very real concern, of course. Nothing about that in this balancing exercise at all. And one recalls that the legitimate aim that we accept, obviously, that of the whole exercise is the promotion of animal welfare. But there are contrary animal welfare issues to that should have been borne in mind.
But doesn't the length of the judgment and the exhaustive analysis of all the underlying materials in the judgment show that the judge knew jolly well what those considerations were?
Not necessarily. Well, 2 points to that, my lady. The fact that the judge has recorded at great length the evidence before the court doesn't show, doesn't tell us much at all. It certainly doesn't show us that all those factors, or what part of those factors, have been put into the balancing exercise.
But it does at least show us that he knew what was at issue, doesn't it?
Well, I think we all, I think we can be agreed that any judge has cognizance of the evidence that's before him in the trial. I mean, that much it doesn't make any difference.
Writing a judgment involves considering the materials that are before the court and putting them in order and thinking about them.
But that's not an analysis of them. It's setting them out in a logical form. This is the claimant's case. This is the defendant's case. This is what the chronology and so forth, which are classic judgment writing skills, of course, that we're all very familiar with.
What analysis is really required, other than to set it all out and say this is what's on one side, this is what's on the other side, and then say my conclusion, comparing the two, is that A wins and B loses.
No, that isn't. No, because it's as Lord Sumption said in Bank Millat. Just remind the court of the exact language that he uses. Exacting analysis of the factual case advanced in defence of the measure. Merely setting out the factual case advanced in defence of the measure and saying I agree is very different than an exacting analysis of that. So we say this is a classic case of the analysis being cursory and perfunctory, as using the language of Mr. Justice Green, and consequently inadequate.
So for the analysis to pass your test, Mr. Wise, what would the judge have to have done, just to give me an idea?
He'd have to have put he'd have to have shown what factors he'd taken into account. The important ones, obviously, not every dot and comma, that goes without saying, but there are obviously important issues relating to the welfare of animals, cats, dogs, animals in different circumstances. There's the issue that I mean, really quite astonishing, that one of the main uses of these devices is in the non-domestic field, i.e. the prevention of worrying of sheep. Now that raises its own very real concerns, and animal welfare concerns on both sides, for the dogs, the sheep, and lambs. There's been no consideration of that, and yet there was evidence before the judge that these devices were a very effective means of controlling sheep worrying.
Sheep worrying happens when a dog is out with its owner for a walk and gets away and worries the sheep. But why can't the owner keep the dog on a lead?
Well, that's not the way in which the judge has dealt with it. He hasn't said, I put on one side of the balance the fact that remote devices can control sheep worrying, but on the other side of the balance that the people can put the dog on a lead. I conclude that the balance falls on one side or the other.
But if you're right and we have to do our own proportionality assessment, are we entitled to take that into account?
Well, obviously, except that there isn't any evidence before the court as to whether that is a realistic alternative to worrying sheep. I raised that point because that's a whole area that just hasn't been addressed by the perfunctory and very short exercise that the judge conducted.
Are those points? I mean, you've referred to paragraph D, paragraph 60, and then the particular context of dogs worrying sheep. Are they reflected in the judgment somewhere?
No. No, it doesn't refer to the Norwegian judgment anyway.
No, but does he refer to the dog, the sheep worrying? Oh, that was the Norwegian search. Yes.
But I'm not sure he refers to that issue either.
No, I see.
But we started this discussion with respect to the other aversive training techniques such as choke chains and prong collars, which aren't proposed to be banned. There's no consideration of what happens with the type of person who may well be inclined to abuse a remote controlled device if those remote controlled devices are banned. Now, the obvious consideration then is, do they go on the internet and buy a prong collar or a choke collar? Now, that's a consideration that should be put into the balance on proportionality. And there is a very real question, not in a position to answer it, but there's a very real question as to whether whether that would be more damaging to the welfare of animals in general terms than a banning of these remote devices.
Well, then you could ban those as well.
Well, you could, yes, but that's not the point, my lady. You could have banned electric shock treatment as using containment systems. But that's again the point why I made great stress on what Lord Sumption said in Bank Malat. The fact that you could ban something else is a relevant factor. But the fact that one person or being or body or product is picked on in the sense that there's some kind of sanction or ban made of them, when there's other causes of the same mischief, can make that banning, that original banning, irrational and disproportionate, which may be a surprising conclusion to some traditional common lawyers, but that nevertheless is what the majority in the Supreme Court have said. So it's difficult to see a better example of what was deprecated by the courts in Bank Malat and the BAT case than what we've got here. We simply don't know what was put into the balance. What the judge did have on predator, so to come back to my Lord's question about the evidence on predatory animals, of course he did have the evidence of Jamie Penrith before him. Very experienced. I think the evidence is something like 1,500 dogs that he trained. which should have been given weight and should have at the very least provided food for a pause for thought. and it's evidence that requires a cogent response. There isn't one, whether it, in terms of rationality or proportionality. So, for all those reasons, we say that it's inadequate and unsatisfactory exercise, and the judge was wrong. The final question then is, what's the consequence? If we're correct, what's the consequence of that? This is my Lord's question from just before the adjournment. The leading case, of course, is that of R, which we've got in the papers. I don't know if the court's had a look at that. I'll take you to it. It's, whether you've seen it before, I'm not sure. It's behind tab 14 in the authorities bundle.
Oh yes. Well, I am familiar with it, since I was in the Court of Appeal.
Sorry, I don't appreciate that. But I'll take you to, I'm not sure, well, I'm sure you're all...
Well, I think it may not be familiar to me, so
Well,
I'd be grateful to have a look at it.
I'm glad I'm not completely wasting my time then.
And I need reminding anyway.
Page 410, we don't need to patrol with the facts of the case. I'm sure your Lordship remembers that. But it's page 4102 of the report. Can I just invite the court to read paragraph 64? Excuse me. And it's in the middle of that paragraph that's the key phrase there, an identifiable flaw in the judge's reasoning. That's what we rely on. That's what we've been submitting all along in this case, under all three heads of our challenge, of course. Where there's an identifiable flaw in the judge's reasoning, it's incumbent upon the court to conduct its own exercise. Of course, that only applies to the proportionality, the A1P1 challenges. On rationality, it's traditional common law territory, and one would expect the court to merely quash the decision. But in convention territory, in proportionality cases, in cases such as this, the court may conduct its own proportionality exercise.
I'm so sorry, Mr. Wise. I think this is my fault. I think I've got the wrong reference. Could you just give me the reference again, please?
It's behind tab 14 on the authorities bundle, my lady. Do you have that?
Yes. So tab 14, I seem to have the same case twice. So I've got the Law Society against the Lord Chancellor behind
that's a disappointment.
tab 14 and behind tab 15.
I'm sorry about that, my lady. It's the Greater Manchester Police case. The
okay. Well, I don't seem to have that.
Have you?
I have got it.
I've got it. Yes.
I've got a road bundle.
So the paragraphs, anyway, were...
Do you want me to get a hard copy to you, my lady?
Well, I can pass this through. But 64, just because there was a bit that you were reading out and I couldn't quite find it.
Yeah. Paragraph, as you see, the paragraph starts in conclusion.
Yes.
If we go 7 lines down.
Yes.
Or let's take the whole sentence. The decision may be wrong,
Yeah.
not because of some specific error of principle in the narrow sense, but because of an identified flaw in the judge's reasoning, such as a gap in the logic, lack of consistency, or failure to take account of some material factor which undermines the cogency of the conclusion.
Yes.
It's that sentence.
Yes. And then there was also something about exercising the court exercises its own judgment.
Well, that's what this passage is all about.
Yes, yes.
My lord, it's those circumstances when it does so. Sorry. If you go back a couple of pages to 4098, you'll see that there's a heading in Lord Cornwall's judgment, proportionality in the appellate court.
Yeah.
And then what he does is considers the previous approaches, which had been somewhat confused. This was, you know, in the early days of this jurisprudence, and it was developing, and there was a question as to whether, firstly, whether the courts always had to conduct the exercise as a public body. Secondly, whether it had to be whether they had to conduct the exercise when the first instance court was just wrong.
Yes, where do they deal? Just show me where Lord Carnwath deals with that.
Plain wrong.
But the appeal, no, the appeal court conducting the exercise is what I'm just interested in. Where does he say that? I mean, he says it negatively in 65. If there was no obligation, contrary to Mr. Southey's submission, for the Court of Appeal to make its own assessment.
Yes.
I mean, is that the point?
Yeah.
Does he say it positively?
That's the issue.
I mean, the alternative is presumably for the appeal court to remit the matter for reconsideration.
Well, of course it could do, yes.
I mean, I'm just thinking here, I mean, the decision in Chief Constable of Greater Manchester, very, very serious for R, but not a complex issue, ultimately.
Well,
but here, there's a mass of detail.
Your Lordship is right, and that raises the point that's raised by Lord Sales in his lecture. I don't know if you've had the chance to have a look at it in the paper. I'm not going to take your Lordship all the way through, but what Lord Sales does in that lecture, it's very interesting. It was November last year. What he does is consider the various ways in which appellate courts have approached this issue, and what he detects is that looking at it broadly, is that there's two strands. There's what he calls the standard cases, and I can't remember what the description is, and the non-standard cases. The R case that my Lord was concerned with would be a standard case. It affects one person, very important for that one person, but that's a standard case, and in those circumstances, a fairly light touch approach by the appellate courts is appropriate, is what is suggested. However, he's saying there are classes of cases, and he cites Nicholson, the assisted suicide cases, as the classic one, which have wider moral issues and affect society.
No, I think what I'm on a more practical point, really, which is that you're saying that the judge below got it wrong, and there needs to now to be a proportionality assessment. And my question is simply this: who should conduct that? Yeah. If you're right about that. Should it be this court, or should we remit it to the administrative court to do that? Because my concern is that in order to conduct the proportionality assessment, there has to be an investigation of this massive material. And none of your submissions so far have been directed to what the right outcome should be. No. I mean, it's not really practical, is it, for this court to do it?
Well, different cases will determine different outcomes.
Well, that's right.
And as a matter of general principle, per Lord Carnwath, the appellate court is to conduct the exercise.
Certainly can.
But that's not set in stone, obviously. No. There will be cases where that's not appropriate. And I do see the force in your Lordship's point that this might be one of those cases which is so multifactorial, to use the jargon, that it needs to go back and have a proper trial of the issues, which essentially is what your Lordship's saying. Trial of the issues.
Well, I mean, we'd have to see what needed to be reassessed, but yes. All right, well, Mr. Wise, I think we should give Mr. Turney opportunity. That I take it completes your submission.
It does, my Lord. I'm obliged.
Thank you very much indeed. Yes, Mr. Turney.
My Lord, can I start, please, with a few factual points, just to pick up some points that Mr. Wise didn't reach in his submissions, and then I'll go on to my substantive submissions. But first of all, I'm sorry, I've realised I don't have my wig on. I'm so sorry.
I hadn't noticed
the mask. And forgot the wig.
I was the other way around.
I'm so sorry. My Lord, can I start, please, just with a question from the court, which was what we know about these collars, and tab 3 of the first volume of the supplementary bundle. So it's volume 2A, it's called. and there is some useful material in the DEFRA research papers that can just provide the court with a little more assistance as to how these colours operate and so on. The reference I went to was page 32 of that bundle, behind tab 3. I'm afraid it's rather heavy going, but part of the objective of this report was to actually understand what collars were on the market.
Yeah.
So there follows at page 32 and following some quite extensive consideration of the nature of these collars, including in detail the voltage and so on. And the functions of those. So there's a description, for instance, at page 35, bottom of page 35 onto page 36 of the electrical outputs, and then at page 36, discussion of the design and the instructions and so on. So there is a little bit more there, should the court wish to consider it. I won't go through it.
No, thank you very much.
The next point, in fact, is in the same bundle. I've got a few references in this bundle. At tab 5, on page 103, there's a description of some of the products which are available. This is a report from the Companion Animal Welfare Council in June 2012. It's referred to in the judgment, but there's a description of the nature of these systems at page 103. And then...
Sorry, I've just noticed my bundle doesn't have a... It seems to go straight from page 98 to 172.
That's because documents were taken out at an earlier stage. That's the reason for that. But I think the relevant...
I don't need that reference.
You don't need that. You haven't. We haven't got that.
Okay.
All right. So it's just the one.
I think I might have a larger bundle in
Ah, right.
Now, can I just quickly? I think at tab. I hope at tab 1 of the same bundle. Well, we know we've got the Danish paper.
Yes.
Yes.
Can I just point out Norwegian? I'm so sorry. Can I just point out at page 2 of that report, the last or the penultimate paragraph of the page, it sets this report in context. The paragraph starts: the use of electronic dog collars as a device for training dogs has created concern for welfare of dogs, and then it explains where that comes from. So this report is really about the flip side. What are the benefits of using these types of devices, as opposed to anything that helps on the question of whether there are adverse impacts on welfare which arise from them. Can I also just observe that the position in Scotland, and there was much toing and froing about this below, at tab 23, which is in the second supplementary bundle, there's a chronology of the Scottish position.
Sorry, this is in which tab?
It's the second supplementary bundle.
Sorry.
Tab 23.
Sorry, you said tab 23, yes.
Yes.
There's a chronology. It's only of tangential reference to the submissions that the court has heard, but it's worth noting that the chronology runs through the period of the consultation and the decision, because effectively the Scottish position was to in November 2017 to say we intend to introduce regulation, and then in January 2018 to announce sort of bluntly that the devices would be banned, and then a sort of backtracking to say, well, in fact, we can't simply ban them, and we're going to look at a more nuanced approach. And so there's a sequence of statements from Scotland which end up in a revised code sometime after this consultation had closed. But the Scottish position certainly was evolving and not clear-cut during the material times for this decision making. So those were just a couple of observations from the bundles. Turning then to the substance of the complaint, Malone and Friend has already gone to Lord Justice Davis's observation in granting permission that it's neither arguable nor argued that that a decision to ban e-collars in itself is irrational, and instead the argument is on the process of getting to that decision. And as we've heard, there are 2 points which are said to justify the conclusion of irrationality: that the Secretary of State didn't also ban containment systems, and that there was a failure to justify February 18 change of position. My case in summary is this. First of all, that the Secretary of State was entitled to draw a distinction between containment and remote operated collars. They have differences which are material to the rationale of the ban. And on the second limb, the Secretary of State was entitled to change his mind. That is in the nature of government policy making. And the change of position was subject to consultation. And the judge rightly found that the change in February 2018 could not undermine the rationality of the impugned decision. On the proportionality arguments, I say, first of all, as per my respondent's notice, that Article 1 of the first protocol is not in fact engaged. I'll have to develop that, I realise. And even if it is engaged, we say there are no less intrusive means of achieving the objective of the ban once the ban is properly understood and the objective is properly understood, and that overall a fair balance is struck. Now, if I may, I know the court has this, but can I briefly go to the statutory framework? The relevant extracts are in tab 2 of the Authorities Bundle. We're in the Animal Welfare Act 2006, that's the power in question. Turning to the 4th page of the printout, we have section 4, which is the criminal offence of causing unnecessary suffering. So if an e-collar or a choke collar or anything else is used to cause unnecessary suffering to an animal, that is an offence. It is a breach of section 4 and an offence, and that's the end of the matter. So obviously the Secretary of State's position is not that the use of an e-collar per se is a criminal offence. We have to look further on to understand what this power is being exercised for. When we get to section 9 of the Act, which is page 7 of the printout, that imposes a duty and creates an offence in respect of steps being taken by the person responsible for an animal to ensure that the needs of the animal are met to the extent required by good practice. So that's a separate offence, and again, it can't be said, it's not said that the use of an e-collar per se amounts to a breach of section 9.1, but what we get from section 9.2 is a definition of what amounts to the needs of an animal for the purposes of the Act, and includes, for instance, in 9.2e, its need to be protected from pain, suffering, injury and disease. So framed in broad terms, there's also reference, for example, to normal behaviour patterns, its need to be housed with or apart from other animals. It's a fairly broad set of needs. Then section 12 deals with regulations to promote welfare. That's the power that's proposed to be exercised here. And I just make the initial observation about section 12.1, that it is a broad order-making power. The appropriate national authority may, by regulations, make such provision as the authority thinks fit for the purpose of promoting the welfare of animals for which a person is responsible or the progeny of such animals. So 12.2 then says, without prejudice to the generality of subsection 1, may in particular make provision imposing specific requirements for for the purpose of securing that the needs of the animals are met, and of course needs is defined in make provision to facilitate or improve coordination in relation to the carrying out of different functions relating to the welfare of animals or the establishment of bodies and so on. And 12.3 confirms that such regulations may include the creation of an offence subject to restrictions in 12.4. So it's a broad power. It can be exercised by reference to securing the needs of animals, but necessarily these regulations are in addition to the generality of sections 4 and section 9. And in answer to the question from my Lord Justice Richards at the outset, or during my learned friend submissions, there is an affirmative resolution procedure which is provided for in section 61
Thank you.
of the Act. That's not in the bundle, but I can provide a copy.
Well, may not be necessary.
Can I turn then to the law in respect of the first? In my submission, this is straightforward, well known to the court. I've explained in my skeleton argument that the approach of the court, the proper approach of the court to rationality challenges is affected by context. Context here, as I've explained, is policy heavy. That's to say that the Secretary of State has a broad discretionary power and he is deciding whether to make regulations to promote the welfare of animals, and necessarily that is laden with policy choice. I've set that out of paragraph 14 argument, and in my submission the judge directed himself correctly on the law, in particular paragraphs 192 to 193 of the judgment. Now, in terms of the approach that my learned friend takes, I quite accept that a Wednesbury challenge may be made out if it's shown that at some point a fundamental error is made in the decision-making process. And of course, that's the easier way to make out a challenge than saying flatly that the end point is irrational. But I say, in these circumstances, applying the law properly, this case comes nowhere near meeting the rationality standard. Now, the court's already gone to the decision document, which is tab 20 of the core bundle, and I just emphasise 2 points on this. First of all, the decision which is under challenge is framed in the context of a response to the consultation. So everything this is in the section summarising the consultation responses, both cumulatively and pulling out individual responses which raise particular points, obviously informs the decision which is then stated at the end of the document. So it can't be said that any of those factors are left out of account. They are on the face of the decision. The government's response then is at 303, and that is the public statement of the Secretary of State's position, and that is the decision under challenge. And I say, on its face, that is a rational process, rational statement as to why steps should be taken as proposed to introduce regulations to ban the use of e-collars. I'll come back to that as I need to, but that, in essence, I say, is a self-contained and full consideration of. It is supported by the individual responses to consultation that go before it, and it is one which the judge was right to uphold. But there's a further important document which I don't think the court was shown, and it really is very important. It's tab 11 of volume 2B, which is the second supplemental bundle,
is this the ministerial submission?
It is, yes. So this is the submission, it's dealt with in the judgment, but it's the submission made to the Minister and to the Secretary of State with the recommendation. But importantly, as well as summarising the consultation process and providing discussion, page 335, paragraphs 1, 2, 3, summarising some of the stakeholder views, it sets out in Annex A the options that are available to the Minister, Secretary of State. Page 340 of the bundle, there are 340 through to page 343, there are 4 options presented with pros and cons. So when, for example, Mr. Wise says that the Secretary of State was silent on the question of regulation, not so, see page 343, which is the pros and cons of introducing a regulatory system for e-collars.
So when we're analysing the decision, is it your submission that we're entitled to take into account the ministerial submission as showing the factors which the decision maker took into account in coming up with the response to the consultation which we've seen in the core bundle?
Yes. Okay. And indeed so did the judge, and I'll go to the judgment because it strikes me that this is an important part of the judge's reasoning and really quite important to the case. So the first option, option 1, was ban the use of all e-collars as proposed, and some of the cons set out in that include, for instance, ignoring the problems for people with invisible fencing where dogs or cats could be put in danger of being involved or causing road accidents. The option of physical fencing may be a problem. It removes a way of controlling dogs, including potentially less able to prevent livestock attacks in motion. It is not supported by a recent research paper by Lincoln University, which showed that invisible fencing containment systems did not have any negative welfare impacts on cats. So one of the pieces of evidence that the Secretary of State had was that whilst there was evidence about the negative effects of electric shocks through remote devices on dogs, the evidence on containment systems for cats was that there was no negative effect on welfare. And then over the page, the option 2, which is obviously the option which was pursued, ban the use of handheld remote controlled e-collars only. And it explains at the top that this would allow the use of invisible containment systems whilst banning the remote handheld devices. Explaining that there would be an update to the welfare codes to say that containment systems should only be used as a last resort, should be installed and set up by professionals with pets and premises in question, and training should be provided. And then the pros are set out there, which largely reflect the points which have already been canvassed. So it's supported by the DEFRA funded Lincoln research, which showed that such devices compromise the welfare of some dogs, allows nonetheless cats and dogs to be kept in a designated area, notes that many attacks on livestock are caused by dogs escaping, and therefore invisible fencing can be a more effective means of preventing escape, and it's supported by the Lincoln University research about the absence of negative welfare impacts on cats. And then the cons, some of them are concerning public support. It would not have total support from the animal welfare and veterinary group lobby. And then it removes a way of controlling dogs, including potentially being less able to prevent livestock attacks in motion, which is to Mr. Wise's point that about consideration of attacks on sheep and so on. There's a risk of legal challenge from ECMA, and then it requires careful handling to ensure that arguments be deployed to distinguish containment systems do not undermine the welfare arguments needed to justify the ban on handheld devices. And then the third option is do not ban, but tighten the current wording in the statutory welfare codes, adopting the same approach as Scotland. And there's a point here, because Mr. Wise says, well, look to Scotland, that was a regulatory approach. But the language that's being used here and the distinction that's being made is that in Scotland there was an update to the code, whereas the regulatory approach that was being considered when ECMA made their submissions was to introduce some form of statutory instrument that would ensure that such collars were only going to be used by trained people and so on. So, in fact, the Scottish approach by August 2018 was to just update the code. And then there's an explanation of the pros and cons. And then over the page, a regulatory system, which is the point that Mr. Wise advances in this call. It explains this would need further development and could include licensing e-collar providers and possibly requiring e-collar users to hold a license. This option reflects the concern that many people are not using e-collars, particularly remote handheld devices, in compliance with instructions. And then there's the pros and cons. The pros include the second point, which is provides for the continued use of e-collars to tackle wayward dogs, which is precisely the argument that Mr. Wise and his clients make. And then the cons, noting a lack of support from some, and then maybe difficult to get through Parliament. And then the next points, a new regulatory system may be burdensome and may be hard to apply if handheld devices are sourced from abroad. A new regulatory system for containment system providers may add little to a robust self-regulatory approach. Many containment system operators appear to act in a responsible way. May be unpopular with owners and keepers if they need to apply for a license. It's unclear how a licensing regime as applied to owners and keepers would be enforced and would operate in practice. So that's why the regulatory approach was rejected. And all of those points, well, not all of those points, but a large number of those points are summarised by the judge. Turning to the judgment at paragraph 70. He summarises the page 94 of the bundle. He summarises the ministerial submission 70 through to 79. Including reference to those options. So really in considering both the rationality of the impugned decision and its proportionality and the approach of the judge to proportionality, one has to have regard to the fact that there was more than just that page summarising the decision. And there was, in fact, this full ministerial submission as well. And it's important and relevant to many of the points that Mr. Wise made in oral submissions. In terms of the evidence from the Secretary of State, there's a witness statement from Mr. Casale, his first witness statement, which was sort of, if I put it this way, filed voluntarily. Which is at tab 16 in the second volume of the supplementary bundle. And again, this is all summarised by the judge. But he explains at page 383 and following the background, the origin of the current policy, and then goes into some detail on the consultation process. And just very briefly, whilst I'm there, on the change of position, as it's put, paragraph 16 of Mr. Casale's first witness statement at page 385, he simply says that in February 18, ministers indicated that they wished to consider a ban on e-collars and sought the advice of officials. On the 22nd of February, officials provided advice setting out 4 options, which were amend the welfare code to ban e-collar use, introduce a statutory instrument to ban e-collar use, a hybrid approach, or introduce a statutory instrument to ban e-collar sales and imports. And the minister decided to pursue option 2, got the relevant approval from Cabinet, and then commenced a consultation, as he was required to do by Section 12. So that gives the background to the decision making. Mr. Casale's third witness statement, which is tab 21, was made, as Mr. Wise has noted, during the course of the proceedings, effectively during an adjournment below. And the judge was concerned that beyond the paragraph I've just shown the court, there was no explanation as to why the Secretary of State went from saying or not taking action to ban e-collars to deciding that he did wish to take action to ban e-collars. And Mr. Casale provides the answer in that statement, paragraph 2, paragraph 3, and explains the position.
Oh, I see. So the court invited the Secretary of State to make a statement.
Yes.
Right.
The position that I put to the judge was essentially that that was enough, because the impugned decision was August, and the Secretary of State was entitled to consult on the basis that he wished to think about whether to have a ban. And it's worth noting that, of course, some of the grounds below were effectively on questions of predetermination, or that the Secretary of State consulted with a closed mind. Now, those were all rejected by the judge and aren't pursued here. So we can proceed on the basis that in February 2018, the Secretary of State had formed a provisional view, but was open-minded about whether or not to proceed to a ban, and that's why he consulted. So I do say that this statement remains unnecessary. I said to the judge it was unnecessary.
Okay.
But we were asked to provide the explanation, and we provided it. Essentially, it summarises the position that ministers initially were of the view that the evidence from the Lincoln research did not support a ban, but that having considered the views of society as it's put, ministers considered there was a case for a change in policy, subject to importantly, public consultation. And of course, as the court has noted, then to a parliamentary process if there was to be a ban. As the court understands, the volte face, as it's put, and the sort of starkness of the change of position really reflects the fact that what was being written in February 2018, early February 2018, was standard lines. What is the government's position on banning e-collars? The government's position on banning e-collars is that they have carried out this research, but they're not satisfied that it justifies a ban. And there was a change. And I don't try to shy away from the fact that that change happened because the minister decided to change position. But that is perfectly lawful and indeed to be expected, because in the formulation of any policy, there must be a point at which the Secretary of State changes his mind, otherwise nothing would ever change. So I don't shy away from it. I do say that this further evidence was not necessary to explain the position to the court and to answer the claim, but in any event it is in, it was admitted, and it's before this court. So I come then to the substance of the irrationality complaint, and I set out at paragraph 15 of my skeleton argument, in summary, the respondent's reasons for proceeding to a ban on e-collars and not proceeding to a ban on containment systems. And in summary, I've set them out, but it's these. First of all, that e-collars can have a detrimental welfare effect on dogs and can cause harm and suffering, a point which is not disputed, could not be disputed, and which is the subject of evidence. Further, many owners did not read the instructions prior to use, and e-collars can be open to abuse. many welfare organisations are opposed to the use of e-collars and consider that negative forms of training which inflict punishment do not necessarily work, can be counterproductive, and can cause dogs to exhibit other problems or dangerous behaviour. And by contrast, and this is important, by contrast, the welfare impacts of containment systems can be minimised, and those systems may avert other risks to animal welfare. And I say just those simple reasons are sufficient to justify the approach that was taken here. And really this becomes, on rationality grounds, I say a very simple case. I then deal with containment systems at paragraphs 19 and following my skeleton argument. I won't go through it line by line, but the judge's reasoning, I say, at paragraphs 197 to 198 is unimpeachable. Having considered at great length the evidence, the judge concluded that based on, as he put it, the two reasons, harm to animal welfare being the first. First of all, at 197, he recognises that containment systems also involve administering an electric shock, and then goes on to say the ministerial submission recognised the potential for inconsistency in this regard. So the Secretary of State was well aware that he could be accused of being inconsistent between the two. And the judge then continued, however, in my judgment, there is a rational basis for distinguishing between the two devices, as set out in the decision. Containment systems prevent other risks to animal welfare. Physical fencing is not a real practical and or affordable alternative. And the pet learns not to approach the fence after having received only one or two shocks. And moreover, there was also the 2016 Lincoln research relating to cats. That's to say, if you, there is no evidential basis at all for banning containment systems for cats on welfare grounds. And then on whether e-collars are open to abuse, the judge was satisfied that there is an inherent distinction, which I say is self-evident, between a device which is manually operated and one which is operated automatically without human intervention. And true it is that one can conceive of ways that a containment system could equally be abused. But the considerations are quite different, because the abuse from administering the shock by a remote device clearly is more capable of being carried out than somehow setting up the system such that it causes unnecessary pain and suffering. And the judge explained that in terms, and also relied on the fact that, as is absolutely clear, the Lincoln research showed that many of the people who use e-collars don't follow the instructions. And of course, as we've already seen, containment systems are, or often are, set up by professionals and could be set up by professionals. So I say that in those circumstances, the judge was entirely right to conclude that there was a rational distinction to be drawn, and that, in essence, is the end of the matter. Now, at paragraphs 22 and following my skeleton, I deal with some of the other points that Mr. Wise made in writing. And I say, at paragraph 23, that the contention, his central contention that every argument not to ban containment systems applies equally to e-collars is just a deliberate oversimplification. It is the same types of factors. That's of course obvious, but they apply differently in respect of e-collars than they do in respect of containment systems for the reasons I've described. And there is, in my submission, a very obvious difference between the nature of the human intervention in setting up a containment system versus carrying a remote control which can deploy a shock to the animal whenever the person wishes to. I say that there's a very clear distinction to be drawn. And in the context of a broad regulation-making power, the Secretary of State was entitled to say, well, I'm satisfied I should regulate in respect, or make regulations in respect of remote e-collars, but that the case for making such regulations in respect of containment systems has not been met. And then the second element of the rationality claim is the change of position. I've already mapped out my response to this. I say that, in essence, the judge went too far in expressing surprise about this, because it is in the nature of government decision-making that the view which has previously pertained in ministerial circles may change. The judge was obviously concerned about it, and indeed, as we've seen, it's apparent he wanted more by way of explanation. But to characterise a change of position as being arbitrary rather assumes that it is a final position, and it plainly wasn't. It was a conclusion that a ban should be consulted upon. He may have been told, of course, through that there was no case for banning. He may have been advised there was no legal grounds for banning, or indeed the consultation may have persuaded him that there was no case for it. But he proceeded in a way which was perfectly lawful to say, I am minded to take this course, and I'll now go through the relevant statutory process, which was consultation process. So my primary submission is that this whole argument is a red herring. There was a change of mind. The Secretary of State's entitled to change his mind, and he then followed the statutory route towards making regulations. The challenge ultimately here is not to the decision to consult, it's to the decision to proceed with the ban, having, in brackets, lawfully, those brackets, consulted. So whilst the judge describes the change of position in rather forthright terms, I say really that's not a matter for the court, because he was correct ultimately in the way he disposed of the argument, which was to say whatever went on in the minister's mind in February ultimately doesn't affect the lawfulness of the decision in August to proceed towards a ban. I've set that argument out in more detail in my skeleton, which I continue to rely on, paragraphs 27 to 31.
So would it be fair to say that the way you're seeking to put it is that there's no minimum public law requirement as to what has to be gone through before you formulate the new policy that you wish to put out to consultation?
That's right.
Because of the consultation is in effect the sifting and purifying process which enables you to come to a fully informed decision after it has taken place.
Quite, my lord. And moreover, if it was shown, for example, that the consultation was not a proper process because he'd already decided to proceed towards
and that was
the
one
ban,
of the issues below, as I understand.
Precisely.
Yes.
And of course, it's through those means that one says, well, the position is unlawful because the Secretary of State had formulated a firm position on this and was inflexible and therefore didn't fairly consult.
So consultation a sham, effectively.
Consultation a sham, and the
Yes.
decision quashed.
Yeah.
But that's not this case. This case is the Secretary of State decided, for the reasons Mr. Casale has explained, whether Mr. Wise likes them or not, but that's the reasons we've given, that he wanted to proceed to a consultation. And I say equally, this Secretary of State, a minister, is entitled to say, I woke up one morning and thought I should proceed towards a ban.
Or I read an article in the newspaper which sort of rang a bell, and engaged me. It could be something as trivial, in a sense, trivial as that, but that doesn't matter, you say, provided the consultation process is then properly engaged in good faith.
My lord, yes, and that's why I don't shy away from my primary submission that this really is a red herring, because it's not good enough to say the point at which the Secretary of State decided. There will inevitably be a point at which the Secretary of State or any decision maker switches between decision X and decision Y. Yeah. The question, public law question, is whether that led to a position which was unlawful because it was a final decision without consultation, or it lacked reasons, or it was substantively irrational. but if one has to sort of evidence a stated set of reasons at every stage in the decision-making process, we can reduce this process to absurdity in my submission.
Thank you.
And I do emphasise I don't really need it because I'm not facing, as I was below, an argument that there was a closed mind. But of course, the Secretary of State didn't pursue the ban that he was minded to. He was minded in the consultation process to ban all systems and didn't pursue the containment device ban. So, my lords, my lady, unless I can assist further on ground one, those are my submissions.
But, well, just on this point about, I mean, I didn't imagine that the consultation document, which we have at tab 9, I think, of SB2A, would have been issued, I think it's there, just following, as it were, a whim on the part of the minister, triggered by just some thought. I mean, there are, trying to see, I mean, it's stated in reasonably definite terms, but it is subject to consultation. So,
yes.
On page 270, it says, we are proposing right now to make it an offence to use an e-collar, slightly over-exaggerating, actually, what could be done. Or even to put one on. So, I mean, clearly a process has been gone through to get to that point, and one would hope that was a rational process as well. But, of course, it's subject to consultation, and in fact, in this case, the consultation did have an effect, as you've described.
My lord, yes, and I hope I didn't sound glib in the way I was describing it. I do say it's a red herring, and I don't want.
I understand
equally,
that. I understand, yes.
As Mr. Casale explained in his statement, the minister approached the civil servants and said, "I want to consider this," and was presented with a range of options. In February 2018, and one of those options was to ban through Section 12 regulations. The minister said that that was the option which he was keen to pursue, and of course the advice necessarily then was, well, you have to consult on that because that's a statutory requirement.
Yes. Right.
And then the consultation emerges in March 2018.
And when we say ban, just to go back to what, I mean, does that mean making it an offence for someone to what? To
put a collar on the animal.
And making it an offence to sell such a collar to anyone in England, I suppose.
The proposal that was consulted upon and the decision relates to the application of a collar to an animal.
So it's making that an offence.
That's an offence.
Yes,
as
right.
opposed to,
I see.
As opposed to banning
I
sale.
see. Yes. Which is why the manufacturers could continue to manufacture and export to countries where their use would not be banned in that sense.
Absolutely.
Including Scotland, I suppose.
And they could sell them here, presumably, to be used. Well, it wouldn't be.
To take
it could be bought for use abroad or in Scotland. Yes.
On the basis of the decision, yes, that's right.
Yeah.
The regulations which were envisaged at the end of the consultation, and as I say, there has been a considerable passage of time, as the learned friend knows, and it is in part due to this litigation, because that certainly slowed things. But as the court will be aware, there's other factors that have affected the progress of matters in government over the past 18 months.
Right.
But in part because of the delay caused by this case, it hasn't proceeded, and the regulations are not yet framed. But the proposal remains to introduce regulations which would prevent it from being these devices from being put on animals,
I see.
and not from being sold.
Right.
Those are my submissions on ground one.
Yes.
Then on grounds 2 and 3, which are essentially two steps of the proportionality exercise, the first point that I have is the respondent's notice case, can I go, please, to supplementary bundle 2B, and tab 12, which is the RTA, the regulatory triage assessment. The court's been shown this briefly, but at page 348, there's an assessment of the impact of the ban and in particular cost to business. And the last paragraph on page 348, this impact is indirect as it depends on how consumers and businesses respond to the ban. In the longer term, businesses are likely to divert their attentions towards other markets where e-collars are still legal and also other products which can still be used legally in England. However, in the short term, these businesses may experience a loss of profits as demand for e-collars in England drops off as a result of the ban on the use of handheld e-collars. And then it says, we do not have strong evidence about the extent of profits currently available in the handheld e-collar market. Therefore, we cannot precisely estimate the potential indirect cost to businesses as a result of this loss of profit. However, we have some indication of the revenue which can be used to estimate potential profits. And then there's a reference to figures about likely costs and therefore revenue. And then lower down the page, this does not take into account the costs that the business will incur in producing, marketing and selling. We do not have any evidence about these costs, so cannot estimate the net profit from selling e-collars with any certainty. In the absence of a better estimate, we have assumed a profit of 20% of revenue. This would suggest annual profits around £0.8 million per year. And the footnote next to 20% says this is a generous estimate. In reality, profit margins are likely to be lower than this. And then notes that in responses to the Scottish consultation, information provided on profits was mixed, with at least one company reporting no profits. However, given the lack of reliable evidence on current profits from selling e-collars in England, we've assumed 20% at this stage. So that's where the 0.8 million per annum comes from. And then we have Angela Critchley's evidence, which the court's already been shown. It's tab 15. The relevant paragraphs are 7.1 to 7.3 on page 379. And the point I emphasise there is that what is missing here, and I'll show the court in a moment why I say this is important, but what's missing here is any explanation of loss of profits and also any explanation of loss of goodwill in the companies concerned. So there is an evidence about loss of sales, and that's as far as it goes. And the same can be said of Mr. Stone's evidence, which is at tab 17 and in particular at page 399. And again, that just refers to loss of sales, saying that there's been losses for particular companies. Ultra, a French company, has seen a downturn in sales of £10,000. Pack Collars has said that there's a downturn in sales in the region of £500,000. And it's reasonable to conclude that other ECMA members will have proportionate declines in their sales as well. But there we are. It is evidence about loss of sales. Now, can I then go to Breyer in the Court of Appeal, which is in the first authorities bundle. At tab 11. The court was shown by Mr. Wise a passage in the judgment of the Master of the Rolls concerning the effect of a proposal as opposed to a final decision. But the passage I want to go to, if I may, is just to understand the concept of what engages Article 1 of the first protocol, and that starts at page 4576 and paragraph 43 in particular. There's discussion before this as well. And this deals, the court will be aware of this rather difficult distinction in the Strasbourg jurisprudence between goodwill and future income. Goodwill being treated as a possession and future income not being treated as a possession for the purpose of Article 1 of the First Protocol. Midway through, or third sentence, paragraph 43, I agree with Lord Justice Ricks that the distinction is not always easy to apply, and it seems the European Court has not addressed the difficulties. And then referring to Malik, Lord Justice Moses, marketable goodwill is a possession, notwithstanding that its present-day value reflects a capacity to earn profits in the future. The important distinction is between the present-day value of future income, which is not treated by the European Court as part of goodwill and a possession, and the present-day value of a business, which reflects the capacity to earn profits in the future, which may be part of goodwill and a possession. Capacity to earn profits in the future is derived from the reputation the business enjoys as a result of its past efforts. And then goodwill is not susceptible to precise definition at paragraph 44, and then at paragraph 45, referring to Van Maal, and then a possession comprising the goodwill of a business is the product of past work. By dint of their own work, the applicants have built up a clientele. Goodwill is the present value of what has been built up. It is to be distinguished from the value of a future income stream.
Sorry, you're reading from where now?
Sorry, paragraph 45 on page 4577.
Thank you. Sorry. Oh, yes, yes.
From an accountant's point of view, this distinction may make little practical sense, but it's the distinction that has clearly been drawn by the European Court for the purposes of A1P1. And then there's reference back to Ian Edgar, which is a decision of the European Court of Human Rights. And just for the court's note, really, there's a passage, a longer passage from that case at paragraph 30 of Lord Dyson's judgment. And this was Ian Edgar was about the handgun ban, and whether the ban amounted to an interference with the applicant's Article 1 First Protocol rights. They were firearms distributors. And there's a reference there at 46, where the court found that the applicant is complaining in substance for loss of future income. The element of the complaint which is based upon the diminution in value assessed by reference to future income and which amounts in effect to a claim for loss of future income falls outside the scope of A1P1. And then the judge, Lord Dyson, considered the cases before the court in Brea. There were cases where there were concluded contracts, and there were cases where it was hoped that contracts or leases would be signed in the future. And at paragraph 49, Lord Dyson upheld the approach of the trial judge, which was having noted the distinction between goodwill and loss of future income is not always easy to apply. In my view, the judge was right to see a clear line separating possible future contracts and existing enforceable contracts. Contracts which have been secured may be said to be part of the goodwill of a business because they are the product of its past work. Contracts which a business hopes to secure in the future are no more than that, and for that reason I'd uphold the judge's classification. So I say that the appellant's case, and indeed the judge, appear to misunderstand that distinction. A downturn in sales is not a loss of goodwill, not an interference with the goodwill of a business, without more. The concern is whether there's an impact on the value of the business and not its future revenue stream in terms of sales of collars, even if those sales would be profitable. And of course, we don't know if they're profitable. All we know is that there are sales. And no member of the ECMA gives evidence that the value of their business will diminish as a result of the decision. We do not even know, for instance, how those businesses are organised. So as the regulatory triage assessment makes clear, it may be that these businesses lose nothing because they may be able to divert to other, even perhaps more profitable enterprises. And it therefore doesn't follow, and it's not enough to say to the court we're going to lose out on sales. Well, that's self-evident. In the same way as in the Ian Edgar case, the sales of handguns would disappear.
But, I mean, in the Ian Edgar case, presumably profits would disappear as well.
Yes.
So a loss of profits wasn't enough. A loss of future profits wasn't enough. There had to be more to constitute goodwill.
Precisely, and it's a difficult distinction, but it's a distinction.
It is a difficult distinction,
yes.
yes.
And for this purpose, we have to apply the, as it were, traditional definition of goodwill, is that right? I mean, going back to Lord Macdonald's famous statement, which is usually at the starting and often the finishing point of this kind of analysis.
I think it is cited in this
That's
case.
how
it is cited.
Yes,
it is.
Yeah.
Yes.
I mean, I mentioned this odd enough because before Christmas, actually, I was in a case in this court dealing with a not dissimilar issue, I think, about the meaning of goodwill in a contract, but it meant looking at Brea and all this question. And the leading judgment was actually given by Lord Justice Coulson, who, of course, had also been the judgment of the first instance in Brea. I mention that just in case there may be anything in that of any relevance. I suspect there isn't. And I'm afraid I've forgotten the name of the case, needless to say, but it was last.
I'm afraid it's outside my researches as well.
But it was anyway. It was before Christmas, and in October, November, December, that sort of time.
My lord, I'll find the case, no doubt.
It might just be worth looking it up in case there's anything in it of relevance. I don't think it will add anything to what we actually gather from
I'm sure Mr.
the passages you're taking us to in Brea itself.
I'm sure Mr. Wise will do the same, and if there is anything, I'll notify
Well,
the court.
thank you. I guess mention that in case there's something there worth following up.
I'm grateful. So in essence, what I say is that evidentially in this case, we haven't met the point at which Article 1 of the first protocol is in fact engaged. The nature of the case that's put by the claimant seems to assume that Article 1 of the first protocol is engaged without actually showing that to be so.
Would you, I mean, since goodwill in this context, as my lord says, is regarded in the traditional sense, it's an item to which a value can be attached, rather than, I mean, Lord Dyson explains how goodwill is normally used now by accountants, which is a slightly different concept. But goodwill is an asset to which a value can be attached. The value will be dictated by the capacity to earn future profits, but established, he says, by reference to the reputation already built up. If you're going to complain that there is a interference with a diminution in the value of your goodwill, would you expect to see evidence as to what the current value of your goodwill is, and the value as a result of the interference?
Well, that would certainly be one way in which it could be.
I mean, unless it's self-evident, I suppose.
It may be self-evident, and in the Brea cases, the claimants in the Brea case were companies which had been set up for the purpose of taking advantage of the feed-in tariffs that were an issue there. So in other words, they were providing services solely for the purpose of taking advantage of those tariffs. Yes. When those tariffs were, well, there was an unlawful decision or statement that they were going to be removed, and then they were reintroduced, and as a result, there was a sort of undoing of all the potential or existing contracts for the delivery of renewable energy under those feed-in tariffs. In those circumstances, it was, I don't know what the evidential position was, but it would have been self-evident that the goodwill of those businesses was fundamentally undermined by the step the government had taken. But I say that's a relatively easy case. The harder cases will be one such as this, where we're told that there are a number of companies which sell these devices. We don't know, for instance, what part of the business, how much of the business does sell these devices. If it's only a small part and the reputation and goodwill of the company is far greater than that, then clearly it may not be enough to amount to an interference with Article 1 of the first protocol.
And of course, any business is subject to the occupational hazard that various lines of product which it sells for one reason or another become forbidden or subject to regulation, or for whatever reason cease to be a mainstay in the way that they were previously. And that doesn't necessarily, again, mean your goodwill is going to suffer. As
PetSafe found in Wales previously, where they also challenged. Now, I do mention in my skeleton on this point that it's the conclusion in PetSafe, Mr. Justice Beatston's, as he then was, judgment in PetSafe, was to the same effect, namely to assume that the
Yes, he didn't really decide it, did he? He just assumed it in favour of PetSafe.
Right. Yep.
I say if he, if it's read as deciding the issue against me, then he's also wrong.
Yes.
But it's hard to say what evidence was there on the facts of that.
Yeah, I think he was adopting a common judicial technique of assume this, and I will then. Yeah. Anyway, the case fails because even on that assumption.
Yes.
Such and such.
So, my lords, my lady, those are my suggestions on the respondent's basis issue. I turn then to my own friend's submissions. First of all, less intrusive means, and I won't go back to Bank Malat, but I do say that my learned friend confuses that principle because Bank Malat is not authority for a proposition that one cannot ban one type of harmful device if another harmful device is not banned. The point there was that the draconian order in question had not been pursued against the other banks, where other measures were considered sufficient. And I say we're not dealing with a comparable case here. There are, of course, various ways in which animals can be subjected to suffering, and a ban on one of those means is not shown to fail at stage 3 of the proportionality assessment simply because other means of suffering are not equally banned.
Isn't that the approach that Mr. Justice Beatson, as he then was, took in PetSafe?
I say essentially he did, and the judge below in this case was right to form the same conclusion.
So I think Mr. Wise was suggesting, perhaps sub silentio, that approach was inconsistent with Bank Melat, but your submission is no, it's not, because it's a different point.
I say it's a different point because it's more, Bank Melat is more a case where, for instance, there are, say if there were electronic remote controlled collars that were produced by 3 different companies, all of which had the potential for exactly the same effect, and the ban was targeted at one of those companies. That was what was happening at Bank Melat, and that was the injustice that obviously sounded with the Supreme Court, having not sounded below. Clearly, there is one can point circumstantially to regulation of other devices and so on to say, well, you could use this means or that means, but I say it's no more than circumstantial. It doesn't get home on applying the Supreme Court in Bank Melat at all. Indeed, I say that in this case, the question of a regulatory regime was considered by ministers, was considered by the judge as well, and it was rejected for the reasons the judge has summarised, and also for the reasons, the same reasons which are found in the ministerial submission. In any event, 2 further points. First of all, that the regulatory regime does not actually avoid the suffering which is in issue here, because it's clear that even properly used, there is pain caused to the dog through the application of the e-collar. That's self-evident. So it's only by stopping it entirely that you are...
Well, but the point made there is that's true of the containment system too.
Yes, I accept that, and true also of a choke collar or of other...
Well, I think maybe, but just focusing on the containment system, the point Mr. Wise makes is, well, you've still got that pain from the electric shock occurring with the containment system.
Yes, and that's accepted, but what the difference in containment system is on the other side of the balance, in particular, that the benefits of containment systems are said to outweigh. And also there's the species point, because which Mr. Wise doesn't deal with, which is that containment systems are widely used for cats, and there's no evidence at all in respect of cats being caused suffering through the use of containment systems. So I say that the fact that the Secretary of State has said that he will tighten the code in respect of containment systems doesn't get my learned friend home on less intrusive means here. That they are being treated differently as a matter of general approach because they are the benefits of the two systems are different.
Well, it is very shortly expressed by the judge. Paragraph 217 is. I don't find it that easy to unpack what he's saying in that sentence, that he adopts what Mr. Justice Beatson said, that regulation would address only the concern about potential misuse. I mean, that all depends what the regulation is, actually, doesn't it? But and then not in particular the harm arising from the electric shock itself. Well, I'm still having slight difficulty in seeing why Mr. Wise's point about the containment system isn't a fair point there.
Well,
maybe because it's anyway.
It's in the context, of course. This comes at the end of the judgment. The judge having already.
So I mean, we've got to read quite a lot into that, you would say.
Yes,
right?
Absolutely. And it's this part of the appeal is focused on a few paragraphs of the judgment, but it's absolutely clear that the judge has disposed of a lot of these issues along the way, and this is drawing them together through the lens of the proportionality test. It really is a sort of criticism of structure as opposed to substance to say, well, he doesn't pull all those factors back in terms in the last few paragraphs. But the judge has already found that there are a number of points which can distinguish containment systems from others, which is 197 to 198 of the judgment. The specific welfare risks, such as straying onto roads, the absence of evidence of any welfare considerations in respect of containment of cats.
Well, the straying onto roads is an example of how the use of a containment system is beneficial.
Yes.
For the welfare of let's say, leave it with dogs for the moment.
Yes.
Welfare of dogs. I mean, you can see that the use of the handheld devices, if responsibly used, could also be beneficial to the welfare of dogs. For example, preventing them from worrying sheep and being shot by the farmer.
Yes, and that's expressly recognised in the ministerial submission. But the different one of the features that comes out on the containment systems and what otherwise happens to animals is that either they stray onto roads and put themselves or other people or other animals at risk, or they're kept inside, and that is the corollary of the not having containment systems made available and fencing not being a practical alternative. And then there's the third element is the inherent risk of abuse, which obviously Mr. Wise says, well, there's a risk of abuse. I say it's a different risk of abuse from a containment system.
I follow that. I suppose what I find slightly puzzling is why Mr. Justice Beatson and Mr. Justice Morris said that regulation would address the concern about potential misuse. It might address it, but it's very unlikely to solve it, I would have thought. Well, is he saying it would eliminate it, or he says it would address?
Well, it couldn't eliminate.
It.
But in the sense that what it could do is provide, I think, on the suggestion, again, it's not the Scottish system, but the suggestion that Mr. Wise hints at and the one that's considered by the government is, for example, requiring a licence to be held by the operator, which of course reduces the likelihood of abuse, because you say, well, if you first of all you presumably qualify for a license, and secondly, if you misuse, you lose your license. But licensing alone, of course, doesn't prevent abuse.
No. I don't know what licensing would involve. I mean, it's one thing to license professional dog trainers. It's another thing. I mean, we're talking about licensing dog owners, and if they've got these devices, they've got to have been gone through a process of tuition on how to use them, and they're certified to be responsible people, likely. And I don't quite know what regulation anyone has in mind here. I mean, we know what regulation is about the ownership of firearms, and it's very extensive and exacting. Is something similar proposed here?
Well,
it's like you may not know the answer to that.
I don't know what's proposed because it's frankly not clear from the submissions that he's.
Yes, well, that's the other thing I'd like to hear you on, because Mr. Wise says the judge was quite wrong to say that it wasn't clear what measures are proposed and how and whether they would work in practice. He says that it was all clearly before the judge.
Well, my lord, can I go to that?
Well, do in your own time. But I mean, don't finish. I mean, if you finished on what I've just raised with you, that's fine. But
no, I'll come to it right away. But I just want to show the court briefly the point in the ministerial submission.
Yes.
Because this is what the Secretary of State has in mind.
Yes.
So it's the last page of tab 11, page 343.
Tab 11. This is in.
Sorry, it's second supplementary.
Yeah. I'm afraid I didn't. I have to say I would have liked this to have been more clearly signposted, this document, in advance of the hearing. I would have liked to have read it. But anyway, page.
It's page 343.
343. Yes.
So this is the sort of fourth option, the regulatory system. It says this would need further development. It could include licensing e-collar providers and possibly requiring e-collar users to hold a license. This option reflects the concern that many people are not using e-collars, particularly remote handheld devices, in compliance with the manufacturer's instructions. Then the pros and cons are set out. It is identified that the ECMA supports a regulatory system, then the cons include that it is maybe burdensome and maybe hard to apply if handheld devices are sourced from abroad, not necessary for containment systems, and then a new regulatory system may be unpopular if owners and keepers need to apply for licenses. Yeah. And it's unclear how licensing regimes apply to owners and keepers would be enforced and would operate in practice. So those are the I think the considerations that would just being canvassed now.
And on any view, it would involve a lot of bureaucracy and form filling and general inconvenience of the type which, on the whole, government is trying to move away from, I suspect, in many. Well, for instance, one used to have to have a license to own a dog, isn't that right? I think that probably went quite a while ago.
I'm not sure you had to show you were any. Yes, it could be taken away from.
It could be taken away from.
That's right.
It's a negative thing in that sense.
But that's right.
37 pence the last time.
The ECMA submission is it's in volume 2A, the first of the supplementary motions. I think it's the last tab of that. Mr. Wise touched on this, but the page 274, the structure is set out, and it can be seen that part 3 of the submissions are concerned with secondary regulations or secondary legislation by reference to other jurisdictions, and it says that Wales and Germany are given as examples where they don't work, and then Scotland is a compliance model that's fit for purpose. And the submissions on that are at start at page 302 of the bundle. What the ECMA was saying, for example, at 137, its ECMA submission that any chosen regulatory system must retain rather than remove training aid options and use under supervision of suitably qualified professionals, operate on a system that encourages dog owners to engage with relevant professions and accommodate real-world practicalities. And then it says, for this reason, ECMA supports implementation of regulations in England that mirror the proposed regulatory programme in Scotland, rather than the model of legislation ultimately implemented by Wales. And it stepped back from pursuing a regulatory approach. And then there's criticism of the Welsh approach, and then over the page at 141 and following, there's reference to the model, which they say is the Scottish model. I think, as I've already shown the court, in fact, that wasn't the Scottish model, but anyway, that's what they called it. And they describe it over several paragraphs, and then at page 305 and following, they suggest a regulatory regime in 7 key stages. And then, so they suggest training of dog owners, licensing of those who are providing training, sale of collars to be subject to that, and then paragraph 155, stage 5, all electronic collar users must engage the services of a qualified supervisor. So I don't know whether that's each time they use the device or at a preliminary stage. And then there's some further, 158, further notable points regarding the proposed Scottish model, and explaining the sort of rationale of it. The examples from Australia of having exams, and then.
Sorry, I'm a little bit confused. I'm just trying to see what was being said here. I think so. As you say, paragraph 138 says that ECMA supports implementation of regulations in England that mirror the proposed regulatory programme in Scotland. So I'm assuming there was at this stage a sort of worked out regulatory programme in Scotland, albeit they moved away from it. And is that what they are then describing in paragraphs 144 and onwards? The 7 key stages at 151, is this all part of the Scottish system?
No, I think that's from ECMA. I don't think that's ever been a feature of it. I don't.
Right.
I don't think it is. And my lord, the factual position is that when this submission was made, Scotland had moved away from the regulations. Right. But anyway, I think they're referring to something that was being considered in 2017 as opposed to what the position was in 2018.
Yes.
But clearly, they do explain a process for training and licensing the use of the devices. And that's the model which is being addressed in the ministerial submission in part 4.
Right.
So,
I mean, was the judge taken through that material about the Scottish sort of, well, what they had put in, what the applicants had put in?
I think from memory, and it's some time ago, there was no extensive consideration of what the regulatory model might be. But there was reference to a regulatory model, and then there was some extensive debate about what the Scottish position was, which was resolved by the agreed chronology that the court has before it. But I think
is the judge's would you submit the judge as justified in his statement that it's far from clear what measures are proposed and how and whether they would work in practice?
Yes. Not least because he's already summarised at between paragraph 70 and 79 of the judgment, the rationale inter alia for rejecting option 4, the regulatory approach.
Yes.
So that's why I say at paragraph 39 of my skeleton argument that 3 points I make at the top of page 13 of my skeleton, that the existence of such models elsewhere did not prove, could not prove, such a measure would be effective in addressing the policy objectives of the Secretary of State, and the Secretary of State was entitled to rely on that system being burdensome and hard to apply, which is essentially what he was saying or what was being said in the decision document. The judge was, in my submission, fully entitled to accept that justification and bound to do so, because there was no real evidence. And Mr. Weiss says, well, nobody disputes the efficacy of systems elsewhere, but really, there's very little evidence before the court on the fact that whether the state of Victoria has a problem with controlling dogs or not, for instance. And there's only reference tangentially in these documents to those other systems. What's very apparent from those documents is that there's a substantial divergence, both within the UK but also across Europe and the wider world, in respect of these devices.
So there's no European consensus?
No, far from it. They're banned in several European countries, and in other European countries there's no control on them whatsoever. I do, as I say at paragraph 39C of my skeleton, the burden of regulation, of course, goes to whether or not the measure is truly a less intrusive means of achieving the same objective. Because if a regulatory burden is such that it's tantamount to a ban, that obviously goes firmly to stage 3 of the proportionality test. So those are my submissions on less intrusive means. And then finally, on the fair balance, by way of preliminary point, I emphasise that the statutory framework is framed in a broad way and expressly provides for the Secretary of State taking measures to address impacts on the welfare of animals. It is an interference with, if Article 1 of the first protocol is engaged at all on the facts, I say it isn't. If it is engaged at all, it is engaged on a narrow basis. That's to say, only on the basis of an impact on future profits from the businesses concerned. So the interference is limited. In terms of the judge's analysis, it is undoubtedly short, but I say that it is not cursory because it comes at the end of that very extensive analysis of all of the aspects for and against the ban through the rationality challenge. I do echo the court in asking what more is there to say at this stage of an assessment in this case. And the fair balance exercise is not an untrammelled reassessment of all the pros and cons of a particular policy. It is whether the right balance has been struck between what has by that stage been found to be a legitimate objective and the interference with the right. In my submission, it is not to be criticised as being a cursory approach. The judge was entitled and should have given weight to the reasoning of the Secretary of State on those issues, particularly in where a very substantial margin of appreciation should be accorded, and that means that the position can be very shortly stated. If I'm wrong on grounds 2 or 3, I do say that although the underlying facts are complex, the judge has put more into the judgment. It's not said that there are factors that are entirely left out of account. They're all in the mix somewhere. And if this court is not satisfied with the exercise that's being carried out, it should conclude that nonetheless, any interference that does exist is a proportionate one. So far as I need to, I rely again on the ministerial submission, on the decision document, and on the witness evidence of Mr. Casale, the first witness named to Mr. Casale, which explained in further detail the approach taken by the Secretary of State. May I turn my back for a moment? My Lords, my Lady, unless I can assist further, those are my submissions.
Thank you very much indeed, Mr. Dillon. Yes. Thank you. Mr. Wise.
Firstly, my clerk came in a few moments ago with the relevant page of, I assume that this was, yes, it's the relevant page of the BAT.
Yes.
You remember, I asked them at lunchtime.
Thank you, yes.
I wonder if we just pass this up to you.
Yes,
it's
please.
paragraph 442, when we've got, I've got a copy from a living friend as well, of course. Richard. It's the cursory and perfunctory sentence that
Right, okay.
you were taking.
Thank you.
I've just been passed a note by my junior who was at the hearing before Mr. Justice Morris, who says, I repeat, that Mr. Justice Morris was taken in detail to the ECMA submissions, and he records this at paragraphs 55 to 61. Instruction that I've just received.
So sorry to ask another question, but was Mr. Justice Green, as he then was in the VAT case, concerned with proportionality in community law, or EU law, rather than
both
ECHR?
Both.
Because he seems the test manifestly inappropriate, isn't it? Is not the Strasbourg test, is it?
Mr. Justice Green in BAT was concerned with every possible manifestation of lawfulness that could be, including EU and ECHR.
But my point is, manifestly inappropriate is not the ECHR test, is it?
Just let me get. I've got.
So this is the
for some
paragraph
reason, I have the full judgment and
you referred to.
I suppose he's saying even in cases where the margin is at its highest, such as the EU.
Yes, I see. Yes, okay, yeah.
I think that
all right, maybe that's what he's saying. All right.
While the court might be slow to substitute its own evaluative judgment for that of the primary decision maker, it will still need to consider in appropriate depth the factual foundation and reasoning.
In response to my lady, perhaps not very helpfully, the judgment is in sections. It's one of those judgments with an index and sections. It's that long, and this is as I see it within section G, ground 3, proportionality. The regulations are inappropriate, which seems to be.
Well, Don't worry, because I take my Lord Justice David Richards' point about what the judge seems to be saying there.
I'm not sure it matters.
No, I don't think it does.
I'm not sure it matters.
No, all right.
He does. He certainly does consider well, the proceeding.
Oh yes, he certainly considered both.
Yeah.
He certainly considered both.
All right.
But of course, he's relying on the at the end. He's relying for his.
Yes, but he refers to Bank Melak, which isn't the CHR case.
Yeah, which isn't a European case, of course. The learned friend places great emphasis on the ministerial submission in his reply. He said on a number of occasions that shows that the Secretary of State had regard to various factors. That in our submission is wholly wrong. The ministerial submission is, of course, a document compiled by civil servants and put in the minutes.
Sorry, so your submission is wholly wrong to say?
Absolutely.
Right, well that's interesting, because I mean, ministerial submissions are routinely referred to in public law cases.
Well, I'm sure that, yes, and I'm sure they are, mainly to show that relevant considerations were all taken into account.
Right.
Now, they're irrelevant in this case because the nature of the case is the rationale, the consistency of reasoning, and so on. Now, you can't fill in the gaps in the Secretary of State's reasoning by referring to a document that somebody else has written that was placed before the Secretary of State. Now, so one has to be very clear on what the purpose of these documents are. It's not part of the decision, the reasoning, or the logic. As I say, if it was a challenge to the failure to take into account relevant considerations, then of course it would be relevant to the consideration of the court. But that's not this case at all.
Well, I mean, isn't there an analogy, for example, with officers' reports in, say, planning decisions? In that those are routinely relied on as showing the reasoning of the local planning authority when taking a decision.
Well, the reasons for the Secretary of State's decision here are as set out in page 303, and different circumstances dictate different results. But of course, between the ministerial submission was after the consultation, wasn't it? Of course.
Yes.
Sorry, I was getting that wrong. But there's a number of factors that the Secretary of State would have been bound to have taken into account. But you can't read in the logic of the civil servant into the decision of the Secretary of State, especially not when he doesn't do so expressly. If the Secretary of State had said, I have considered document X and I agree with paragraph Y or whatever, that may well be a different matter, but that's not this case at all.
Not really back to a very basic point of how one interprets any kind of public statement, which is you have to do so in context, and part of the context is the material available to the decision maker.
Well, that's right, to understand the document.
Yes.
But we're specifically concerned here, my lord, with the logic and reasoning.
Well, I follow that. Come on, draw a rigid distinction. I mean, what the reasoning has to be. The reasoning is itself a process of interpretation of what was said, and the chain of thought which is disclosed.
The chain of thought. But the chain of thought of who? It's the Secretary of State. It's in the decision itself, of course. Now, the civil servant's documents may well inform the decision-making process. Of course, they may. That's what they're there for. That's their job. But we can't assume that the civil servant's documents were all accepted. That's a different matter.
But the ministerial submission sets out the background and puts 4 options in front of the Secretary of State.
Yes.
If the Secretary of State chooses one of those options, are we not entitled to infer that the reason he chose the option was because he was persuaded by the factors that were advanced in the ministerial submission?
Well, in some as my Lord Justice Henderson just said, that would depend on context. In some circumstances, that may well be correct, but not here, my lady, with respect, because we have a separate freestanding document that sets out the reasons for the judge's for the Secretary of State's decision. Which makes no reference to any extraneous documents. Certainly makes no reference to the ministerial submission. So when my learned friend said the regulatory proposed regulatory system was rejected, see the reasons set out in the ministerial submission, we would say that just doesn't follow. The Secretary of State doesn't say,
the judge was wrong in that respect as well, then. Because in paragraph 217, the judge relies
Just bear with me one moment.
on the ministerial submission.
Well, he's dealing with, but he's dealing with the proportionality. He's not dealing there. The judge is in 217 dealing with the rationality.
You're on the your ground
States.
one. At the
Absolutely.
moment. Yes.
I mean, obviously, the
Yes.
ministerial statement goes into the mix on proportionality when we're considering, because it's part of the evidence. That goes back to the old thorny question. Sorry, of who's the primary decision maker. It's before this court, the court below, and the Secretary of State. But it doesn't go to the rationale, the reason in our submission. My learned friend's submissions on irrationality were we say with respect dealt rather more concerned with whether it was a decision that the Secretary of State was entitled to take, i.e. the first limb of the Wednesbury test, and not the second limb, as to whether there's a proper logical explanation for the decision, and in particular whether there's a logical explanation for treating the two e-collar systems that we've been discussing differently. My learned friend's main point on that is it's an oversimplification to say that the facts of the same facts, that it's an oversimplification to say that the same facts apply to e-collars in containment systems and remote systems. But we didn't say the same facts apply. What we say is that they both apply electric shocks. That's a different thing altogether. And as we said, we described, if the mischief is to minimise the risk of endangering the welfare of animals by reducing the exposure to electric shocks, it's very difficult to understand why to see a logical reason why the two systems have been treated so differently. With respect to interference and the Breyer case, my learned friend said at the end of his submission that it's self-evident that goodwill in the companies in the Breyer case was reduced, because those companies were set up to provide the businesses which were the recipients of the grants that was the subject of the case. And that's absolutely correct. But exactly the same applies here. We are the Electronic Collar Manufacturers Association. It's our reason to be, just as it was the reason to be of the companies in the Breyer case.
Yeah, but Breyer, I think the companies only succeeded in relation to existing contracts. They didn't succeed vis-a-vis the prospect of future contracts.
But the point, with respect to whether there was an interference.
Yes. Oh, I'm sorry, that's the different point.
Yes, that's a different.
Sorry, of course, Brer is 2 points.
Yes.
One, you're on the first point. Yes. Sorry, forgive me. That's my fault.
Absolutely.
Yes.
My lord. And obviously, there are difficult questions about quantifying goodwill.
I took you out of turn. I'm sorry about that.
But at the end of the day, we say that the judge, who's very experienced in this area, was entitled to come to the conclusion that he did on Bray. Just bear with me one moment. Yes, it's this sentence. Sorry, I was struggling to find it. It was in Lord Dyson's paragraph 72 in Bray. The proposal did have a practical adverse effect on the claimant's businesses and therefore amounted to an interference. Yes. Now, one can dress these things up in very complicated concepts. Of course they are in company law. But Lord Dyson, with respect, we would say is quite right to take that broad brush approach, which is intuitively correct. We would suggest when we're dealing with broad concepts concerning fundamental rights. So we would say that the judgment made by the judge below that there was an interference here is consistent with what Lord Dyson says and shouldn't be interfered with.
Well, I mean, he Lord Dyson says in paragraph 72, I reject the submission that a mere proposal cannot, as a matter of law, amount to an interference. Well, that's binding on us.
Yes.
Yeah, well, that's fine. But the question is, was there a possession?
Yeah, exactly.
Well, that's the difference. I mean,
yes.
Yes.
Reading the whole paragraph together, putting all those bits of the jigsaw together, we say that there's a direct analogy with our present case. That's
This is Bray you're talking
yes.
about. Yeah.
Paragraph 72 of Bray.
Well, I understand. We understand that. Yes.
But what the judge has done is drawn an inference from the evidence that he had.
Yes.
The capital value of the goodwill of the member's
Yes.
business was adversely affected by the knowledge that e-collar sales would be prohibited.
But if the ultimate test, my lady, is as in Lord Dyson's last sentence of paragraph 72, whether the proposal had a practical adverse effect on the businesses.
Well,
there's no question.
Well, there are two issues, aren't there? There's what amounts to an interference, whether you have to have a legal effect or whether a practical effect is enough. But the second issue is, what's the possession for the purposes of A1P1? And that's where this question about the effect on goodwill comes in.
Yes, it is, and obviously there's a great deal of discussion in the preceding paragraphs.
But I mean, the judge has assumed that an effect on goodwill is required, and he's drawn the inference that there would be one.
Yes.
From the I must say, rather sort of skimpy evidence that was in front of him.
In our case.
Yes.
Yeah. Yeah. Well, we say he was entitled to.
All right.
With regards to less intrusive measures, my learned friend seeks to restrict the scope of Bank Millat. Bank Millat is setting out in broad terms the correct approach for the courts in A1P1 cases, establishing principles that should be applied by the courts more generally. They aren't to be given. So, for example, when my learned friend said in conclusion of his submissions that his client should have be given a very substantial margin of appreciation, which means that his decision could be very shortly stated. That's directly contrary to the principle set out in Bank Millat in our submission. No matter how wide the margin of appreciation, there's still got to be the exacting degree of scrutiny of the decision. It can't be perfunctory or cursory. That perhaps is the main, more general point that derives out of Bank Millat, that where fundamental rights are concerned, whether property rights or human rights.
But do you accept, Mr. Wise? I mean, it would be one thing if the judge had simply stated if his entire reason was contained in those paragraphs, but against the background of his extensive consideration of the rationality of the decision. I mean, isn't one entitled to read that in?
Well, paragraphs 197 and 198 certainly, and I would accept Maloney's submission on that. Of course, that's relevant.
Right.
But even that's fairly cursory. Maloney Friend's submission went much further than that. What he said is there's an extensive analysis in the judgment, and we took that to mean throughout the whole of the judgment.
Yes.
But that's not the case with respect to Maloney Friend. What he's doing in the judgment as a whole is reciting the facts. And so, for example, he sets out the relevant paragraphs of the Lincoln studies. He doesn't analyse.
But in his discussion of the rationality of the decision, there is a fairly extensive consideration of the evidence going in both directions. So I mean, what I'm asking you is, are we entitled to read that in as part of the background to his consideration of less intrusive means?
Yes, but even that, Malay, you say extensive discussion. I'd referred a moment ago to 197 and 198.
Yeah.
But we're only adding 194 to 196 to
Yes.
197. That is a bit more, of course it is.
So are we allowed to take that into account as well? I just want to understand what your submission is.
Well, of course you can take that into. Of course you do. Our submission, in short, my lady, is that there hasn't been the proper, detailed examination of all the necessary information, particularly the reason, the justification provided by the defendant. But when one looks at those paragraphs that my lady just referred to, there's very little in there in any event, because 194 is the judge scratching his head and saying it's not a straightforward issue, and then 195 gives a little bit more background, but frankly very little in there. The implication from the Maloney Friend submission was that there was an analysis and judgment throughout the judgment, and we say that that's not correct. In a more limited sense, it is correct. That you can have a look at the other paragraphs in the judgment. Maloney Friend said at one point that when considering less intrusive means, that the e-collars cause pain, and that's a sort of emotive language that doesn't really help, because there's no evidence whatsoever that e-collars cause pain to an animal. None whatsoever. No expert.
What does it do?
No. It gives a pulse or
what is a
remark.
pulse?
And all we know,
what is a pulse? I mean, just a sort of tap or what? I mean, when you say it doesn't give pain, I mean.
I asked to say, if you don't mind me giving evidence,
it seems to me
I asked exactly the same question,
yes.
and for that reason, and it's a shame we can't do that, but for everybody, I actually asked one of the people instructed me to put one on my hand just to see how I was, and it certainly wasn't like touching an electric fence that we were aware of.
But you're not a dog. I mean, do we really?
You're right.
But do we really know what dogs feel? I mean,
well, that's a very good question. That, my lady, is a very, very good question, and I certainly don't hold myself out to be an animal behaviourist, although
I must say, Mr. Wise, I really don't think we'd be here if these devices didn't cause the animals some pain.
Well,
what if it doesn't cause pain? How does it learn not to do?
Well, they have an adverse effect. I mean, so
what's an adverse effect?
well, what we do know is that some of these devices vibrate and some of them.
Yes. Well, vibrating is probably fine, isn't it?
It matters well.
So, unless vibration has a particular effect on.
But the purpose of a vibrate of that is to detract the dog from doing whatever it's doing. So if it's fighting another dog, then it gets the pulse.
Whatever it is, it must be a deterrent.
But if the red mist has descended, it will have to be something quite.
Well, I don't know. We're in the realms of we have to be very careful. We're in the realms of speculation. But
I doubt if we are. I'd be very surprised. I mean, my lady asks. I think there's quite a lot of work done on whether animals feel pain and so on and so forth.
Well,
I'd be very surprised.
Well, instinctively, I'm sure we'd.
But I would have thought if you were telling us that the animals don't feel any pain as a result of this, you would have had that research paper up front as the #1 exhibit.
Well,
and so on.
Well, I've gone through all these papers and I've seen nothing that says that these devices cause pain. All they say in Lincoln is that it raises the cortisol levels. Now, I don't know what that indicates. I'm not a scientist.
Stress. It's a response to stress.
Yeah. Right. That's and then it's assumed from that the tentative. I mean, they are very tentative. The conclusions of the Lincoln. So they tentatively suggest that I can't remember the language now, but you were taking to it earlier. It's that it's adverse to the. Adverse to the dog. But yours is quite right. Of course, they're going to feel
something they wish they didn't.
In fact, I'm sorry. I'm reminded that there is a document in the papers that might just help on this a little bit.
It's getting rather late in the day.
It is.
In the reply in the Court of Appeal.
No. Well, it's in the papers. It's in the papers. Whether this is just a matter of interest or legal submission, we shall see. But if we go to this bundle, which one is it? The second of the supplementary bundles. The tab 22. This is a document that we learned from the index, was an ECMA document prepared, a technical summary of the electric shock collars, which I think was done for the court below. Is that right? Yes, it was done for the court below, in fact. So if we look at the first page of that, ES is electrical stimulation. We've got low, medium and high, sensation, annoying, startling and uncomfortable, training goal, gaining attention, interrupting behaviour and inhibiting behaviour. That doesn't mean that you couldn't turn the dial too high and it would be inappropriate. Of course, it wouldn't. But that's the way it's put.
I mean, look at the top of that page. Minimum standard. Training aids must not be used in a way that causes unreasonable or unnecessary pain or distress to a dog. I mean, causing pain, surely, is what we're talking about here.
Yeah. Well, the evidence is
So there's a reference to them, avoiding things that make them feel bad, pleasant and unpleasant stimulation. I mean, aren't we rather dancing around?
Well, we accepted, didn't we, in opening, of course, that obviously they have an adverse effect, else they wouldn't be much use for, they wouldn't be fit for purpose, and of course they do. The whole debate is concerning restricting the inappropriate use of things like this and causing unnecessary harm. Nobody wants to cause harm to unnecessary harm to animals. I think that's one thing we're all agreed on both sides of both parties. So, just to return very briefly, I see the time, and it won't be many minutes. My learned friend was, we're now just discussing his submissions on less intrusive means, and he says that he relied there very heavily on the ministerial submission. We've dealt with that. We can't, in these circumstances, conflate the ministerial submission with the Secretary of State's decision. We then looked at some of the particular types of, and he said that, by the way, on the ministerial submission, that Miller friend said that the judge is entitled to accept what was said in the ministerial submission, but the Secretary of State didn't say that he accepted what was said in the ministerial submission. On regulations, of course, regulations have to be justified, but the question we're asking here is whether they're a least intrusive method and cause a lesser interference in my client's right to property. That's the question. Nobody wants regulation for the sake of it, but of course there are numerous areas where regulation exists. On fair balance, my learned friend said it's a limited interference. Well, the evidence is that it's likely to be in the millions. That's not a limited interference in our submission, and that should be given that that's the fundamental right, that should be given considerable weight. Just before I go to that, a point on, sorry, just backtracking to the regulatory least intrusive method point. The suggestion that it isn't possible to regulate e-collars to minimise any detriment or harm to animals, we would suggest is fanciful. The suggestion is that it can't be done, or that seems to be the suggestion. But of course it can be, it's fanciful to suggest that it can't be done in just the same way as many other potentially harmful things such as pesticides and so on are licensed and regulated and so forth. On fair balance, my learned friend said he struck the right balance, but that of course is outcome, not process. We're concerned primarily, or at least initially, with the process and whether there was a proper balance struck. Were all the relevant factors weighed in the balance and considered conscientiously before arriving at the conclusion? Well, we say in the very brief analysis that the court below did that they didn't do that. The final point my learned friend was made on relief, in which he says that even if the essence of the submission, I think it's fair to say, was that even if there was a technical breach, the court shouldn't go on to make its own decision in favour of the appellants because of its own assessment of the evidence. We would say to the contrary, that on the evidence there's clearly a logical inconsistency in the reasoning. They're clearly wrong to have found that there wasn't a least intrusive method and there was a failure to do a proper balancing exercise to demonstrate that the measure was proportionate. Always bearing in mind, of course, that the burden's on the Secretary of State to show that it's a proportionate measure. Those then are my submissions in reply. I don't know if there's any other matters I can help on. Your Lordship or the Ladyship.
Well, thank you very much, Mr. Wise.
I'm so sorry to rise at this point, particularly at this time, but I hadn't quite anticipated what my learned friend would say about the role of the ministerial submission. Could I just ask the court to read, not now, Casale witness statement number 1, which is tab 16 of volume 2B, and paragraph... Casale 1. Casale 1.
And that's tab
16 of volume 2B. And it's paragraphs 48 to 59.
48 to 59.
I'm sorry to rise at this point.
No, thank you very much. Very well. Well, thank you both very much. We will reserve our judgments, which will be circulated in the normal way for the usual type of corrections, please. Hand down will be remote, and we hope you'll be able to agree in order. Let us have any submissions in writing if there are any points of dispute. Thank you both very much.